Hi, I'm Sara Bronin, and welcome to Property Law 101. I created the series to help you understand the basics of property law. And we consider 4 questions in this series. And today we are talking about the second question, acquiring property. So we have talked in other videos about how possession can be a really important way to show title. One way to show an interest in land and to obtain title through possession is through a doctrine called adverse possession. This doctrine allows someone who is occupying land owned on paper by someone else to come to own that land. So this might be surprising to you. Someone can just go onto real property, onto land that you own, and if they do the right things for long enough, they can own it. A separate video covers the rationale for this rule, but in this video, we're covering the elements of adverse possession. These vary from state to state, but generally there are a few common key elements. So the first element that an adverse possessor has to show is actual possession. In other words, that they actually occupy the property, that they live on the property, conduct business on the property, or have built something on the property like a fence. A second element is exclusivity. So the adverse possessor and true owner cannot occupy the property at the same time. The adverse possessor has to occupy the property exclusively. If 2 adverse possessors are occupying at the same time, however, they can come to co-own the property together against the true owner. Third element is visible. That means open and notorious in some courts in some states. It means to the common owner, to the common person, they can see that you as the adverse possessor have exercised rights of ownership. Another element is continuous. So this might depend on the kind of property. If it's vacation property, you can show continuity if you are using the land during, let's say, summer periods. If you're in Alaska, there's a case that shows that someone had continuous possession when he went to pick berries on the property during berry season. Another element that might be important is adverse or hostile or without possession. States differ on the state of mind that an adverse possessor or true owner has to have. Some states who care about the true owner's state of mind look at whether the owner might have actually permitted the use. The presumption is that if the owner permitted the use, there cannot be adverse possession. In the situation of co-owners, the co-owner who's excluding a fellow owner actually has to be very explicit about the exclusion, and their state of mind is very important to a court. They actually have to engage in actively ousting the co-owner from property in order for them to make an adverse possession claim. For those states that look at the adverse possessor's state of mind, the most common view is the objective statement that the adverse possessor's state of mind is irrelevant. So I should say maybe only a handful of states look at the adverse possessor's state of mind. Some states who do require bad faith. So require the adverse possessor to say, I knew I didn't own the property, but I intended to make it mine. Other states require a showing of good faith. I'm the adverse possessor, but I thought I owned it. Courts are, from an empirical perspective, less likely to award title when the adverse possessor demonstrated bad faith. They are more likely to make them pay for their time in possession. The last common element across states is the statutory period, the period defined by statute, that an adverse possessor actually has to occupy property before he or she can claim ownership. This varies dramatically from state to state. There are some states with as few as 5 years for the statutory period, and there are some states with as many as 40 years. In Connecticut, for example, the rule is 15 years. In developing a statutory period, legislators have weighed a variety of factors. So for example, how long monitoring a property must be mandated, the cost of litigation, the cost of title searching, how far people have to go back in title. So the statutory period is the last thing that I would say is pretty common across states. There's a couple of other elements, though, that you might need to take into account for some states. Some states, for example, require what's called a color of title. In other words, the adverse possessor thought that she had a good deed, the good piece of paper that says that she owned the property, but she didn't because there wasn't a signature, because the person conveying the property didn't own it, because there is a bad description, a mistake in the description, the land description, or because it was produced through a faulty procedure, like a tax sale when the sheriff didn't follow mandated procedures. So sometimes color of title is important for, in some states, to show an adverse possessor has a rightful claim. Sometimes the adverse possessor's state of mind is referred to as the claim of right. So when you hear the phrase claim of right, that refers to a mistaken belief of ownership. Sometimes states will require for property taxes to be paid. So one state that requires adverse possessors to have paid property taxes during the entire statutory period is Florida. Once someone shows they have satisfied these elements as they apply in the state that the property is located in, they receive title to the property. So you can imagine situations, particularly in the case of an unsophisticated true owner, where this procedure and this legal doctrine might be abused. I will leave it at that. I look forward to hearing from you, whether on Twitter or through my website where you can sign up to my mailing list. And I will see you next time. Thank you.